All right, I'm going to call this morning's docket. When I call your name, please say present or here and raise your hand so I can mark you down. All right, Kenneth Lee Taylor. I see that Mr. Taylor is appearing via Zoom. Court has approved that. Mr. Taylor has indicated he's tested positive for COVID. He is present online. We'll recall his case. He is unrepresented at this time. Tavares Dixon.
Your Honor, on behalf of Mr. Dixon, he lives in Alexandria. We were last year, we announced that we had a state agreement in place. He asked if he could appear by Zoom today. Court's condition for that was that he pay the restitution for fees ahead of time. Our understanding from our legal system that has not taken place. And Mr. Dixon is currently sitting in a living room somewhere in Alexandria, Louisiana, waiting for a Zoom.
Okay. All right. I'll recall that, Mr. Adams. I appreciate this information. Carlos Gatlin. Thank you, sir. Billy Otmo. Michael De La Rosa. Michael Elias De La Rosa.
Warner, I saw Mr. Bogan here a minute ago. They may be in the hall.
Okay.
I have not seen Mr. De La Rosa. I have seen.
Okay. We'll recall. Terry Martin. Terry Anise Martin.
Again, Mr. Bogan's client. I don't know what she looks like, but I have seen Mr. Bogan. He did look alone.
Will you step out and find Mr. Bogan and see if he, or Mr. Waddell, see if he can confirm if his clients are here or not here, please. James Rife.
Here you are.
Royce White. Veronica Wortman.
She's present. She's
All right, thank you, Mr. Hawkins. I've got the state's motion on that as well. Bobby Brand. Appears, I have a note that Mr. Brand may be on the Palestine Regional Psychiatric Unit.
That's what I was.
Mr. Manning said he was in a bench trial or he's in trial of sobriety, and I believe he said Kaufman County. Oh, is he downstairs? Okay.
Downstairs. Mr. Abraham, did we get any kind of documentation about that from the father? Okay. Okay.
So maybe it's here.
Shane Baronet.
He's here, John.
Thank you, Mr. Mims. Jason Mays. Jason Lee Mays. Jacqueline Jacobs. Cody Ledbetter is verified in custody in Kaufman County. We'll recall that, schedule that. Obed Mingastu. Obed Mingastu.
Sure, that's been Mr. White. I have not seen Mr. White. We might want to check if there's a waiver.
There may be a waiver. All right, there is a waiver filed on Mr. Mingastu by Mr. White. Pretrial is set August 23rd. Ms. Burns, do you want to reach out or have Mr. Waddell reach out to Mr. Colin White in order to get Mr. Mingus to the final conditions of his release? All right, council, do we have anyone that's ready and agreed? Billy Otmo, CR 2241. Morning, sir. Morning, Judge. How are you? Doing great. Yeah, right here to the podium. So we can move that small microphone at the podium. Yes. Mr. Bingham, on the, and Mr. Woodwhite, on the state certificate of discovery, is that sufficient? Is that discovery's been received? I don't know if this complies with Morton.
Well, I, for the record, Judge, Ms. Curry sent those to me late last night. I don't know the numbers. They supplied us with what we believe is complete discovery in the case. There's nothing that we've read that indicates we haven't received anything, or there's anything missing. The DA's office is, as usual, has, I think, provided us everything they have. We're satisfied with it. We believe the DA's office is compliant with grading. I did not have the numbers, but I could supplement that to the board and get something signed to supplement the record with it. But they provide us with everything we believe exists, and we're satisfied that with what they provided, have no indication of this.
Is it just not pulling again?
Judge, it's just not pulling. I'm not sure why. If the court would prefer, and with Mr. Bingham's permission, I'll just take a screenshot of what we have. He can review it, make sure that we've given him everything that we have, and we can just supplement the case file and the pretrial intervention in just a few minutes.
Okay. Yeah, I'd prefer that. I just want to have absolute assurance that the defendant is certified, the state's certifying what was in discovery, what was provided. I'm sure Mr. Morton thought that he had everything that was provided by the state as well. So that's always a concern that I'm looking for. So yeah, if we can supplement that, that'd be much appreciated. All right, Mr. Otmo, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear or affirm that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may put your hand down. Mr. Otmo, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
In this case, you are represented by your attorney, Mr. Matt Bingham. Are you pleased with his representation of you?
I am.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about this pretrial intervention contract that you've reviewed and signed along with Mr. Bingham that you do not understand?
No, sir.
Mr. Bingham, do you believe that your client is competent today and that he is intentionally, knowingly, voluntarily waiving the rights as indicated in the pretrial intervention contract?
He is competent. We discussed this case on one occasion with the discovery. He's been able to assist me in the preparation of any defense that he may not have had, talked about the case. He is making his own intelligent and voluntarily waiving the rights that he would otherwise enjoy in this case.
So Mr. Otmo was originally charged with assault against a public servant. Is that correct?
And he was, and Judge, I know this court's position on those kind of cases. So I want the court to understand, while we're not going any stone to the state, we think that although it may have technically fit, what this was, Mr. Otmo's house, they entered through a certain area of her house. A person who works for the water department was there reading a meter underneath a bathroom window where his wife was showering.
Water test.
Water test in the backyard. I'm sorry, not reading it, water test. That at some point, when they, not knowing who was there, he came around the house, confronted the guy doing the water testing. And originally it was alleged that he displayed a weapon. We think obviously the DA's office had sufficient belief in the probable cause making the charge that way. We contend he did not, but I didn't want the court to think this was an aggravated assault with a police officer kind of scenario. It was, his words were exchanged. Mr. Otmo was upset. This was underneath the window where his wife was showering. No one was injured. So Mr. Otmo's a very good man. He has a very good family. He's recently married, has young kids, and the state has talked with us. Scurry's understood our position very well, but I did not want the court to think this was what it may sound like. Which that was the next.
All right, thank you, Mr. Bingham. I do appreciate that. I noticed that there is no evidence attached to the stipulation of evidence. Is there a reason for that? Typically, there would be evidence attached to this that there's a stipulation. So far, it looks like the only thing that's being stipulated. There's a broad statement about evidence in this case, but there is no evidence other than the judicial confession of this paragraph.
That is probably because we had gone back and forth with paperwork. It might have been attached to a different. This current now been going back and forth because of the reduction and just basically kept changing. We have no objection to them including something in there about the report they want to. I'm not sure that was ever.
This is Ms. Curry's case, so we don't know what the negotiations were. That was the paperwork that we were given. We'll print up the police report and attach it as a
I
stipulation.
mean, that's up to you. I mean, it's a B misdemeanor. I mean, the court could accept a plea just based on the judicial confession alone for a misdemeanor, it not being a felony. But should Mr. Otmo violate the pretrial intervention contract, there may be some issues getting any of that evidence in. And if there's an argument that he stipulated to it, there's evidence here that he's not stipulated to anything.
We'll be happy to sub. We will. I'll send something to the Scurry that satisfies that. Keep it in her file.
I was going to say, we just printed the police report. If Mr. Bingham doesn't object to including that as the
Stipulation of evidence, Your Honor.
All right, so Mr. Altmo, you understand that the court approves this intervention contract today for the offense, the reduced offense of terroristic threat, a Class B misdemeanor, that you would be on this program for a period of 2 years and you'd be required to comply with each and every term that's indicated in your contract?
I do, sir.
And you also understand that in order to enter into this contract and this program, that you would be waiving some rights today. One of those very important rights would be the right to a trial by jury. You understand, as we sit here today, you have the absolute right to have your case tried before a jury of your peers. And during that trial, you have the right to confront the state's witnesses and their evidence in front of a jury. But if you waive your right to that jury, that right would not be restored to you after the completion, either successfully or unsuccessfully of this program. Meaning, if you violate the terms and conditions of this contract and you're brought back to the court and the state seeks further prosecution of you, you would not have the right to a trial by jury. You understand that?
I do, sir.
You've discussed that fact with your attorney, Mr. Bingham, and are you intentionally, knowingly, and voluntarily waiving your right to a jury trial today?
Sir.
All right, the court will find that Mr. Otto has been admonished on the record as to his right of a jury trial and the waiver thereof and its consequences, and the court will approve the waiver of jury trial in this case. Now, typically in these contracts, there's also a waiver of rights with regards to certain expunction of certain criminal records. However, I see here that the state's waiving is limited expunction. Is that correct?
I thought it was very one of the things we read that to mean that during the term of this pretrial conversion, they would not try to expunge either the ag assault or the terrorist threat case, but upon completion, we do want to expunge those charges. One, they would both have been dismissed. My understanding of this Curry was they did not want us trying to file something to expunge like it was on the pretrial conversion, but at the completion, that we would be allowed to do that. If that's a big deal to us, so.
Well, and I understand, I believe that, and I'll just, in all transparency, I created this program when I was in the DA's office.
Okay.
And so it might not be the intent of the DA's office at this time, but the waiver of the speedy trial and limited waiver of expunction, it protected the DA's office from an individual coming in and getting pretrial, successfully completing it, expunging records, getting another offense, seeking another pretrial intervention. So in my experience, the waiver of expunction was waived. I'm sorry, the right to expunction was waived only to the DA's records, so they would know who they've extended PTI to, and also to the probation department, so they would know who they've supervised before. If this is your agreement, that's fine. I have no problem with it, but I'm going to want the state to sign this. And right now, the state hasn't signed this.
And Your Honor, this, Ms. Curry did not mention to us that we were making an exception to our policy. That's my understanding of policy as well, is that we retain our right to the records, but we don't oppose a formal expunction.
I have no problem with that. If they're maintaining their records, but we're still expunging the NCIC, TCIC, I don't have any problem with that. Also, as long as that would not be subject to no records requests or something from normally expunction, but if y'all kept them, that it would be that caveat that it was not open to an open records request should another employer file no records request. We have no problem with the DA's office or probation keeping it, have their own records. That's, we kind of hope once it's done, but I understand the utility in keeping it. I just don't want it to be subject to open records or, and I guess maybe I misunderstood what she was saying. I thought she meant, because some offices do it where there's nothing pending, it should be dialing, it could be expected. So maybe it was my misunderstanding. But I have no objection to being able to expunge it except for the DA's office or probation, as long as it's not subject to a FOIA request.
But I'm not sure the DA's office could resist a FOIA request or an open records request, because if Mr. Otlo successfully completes, as we hope he does, and the records are maintained by the DA's office or the probation department, and they are requested that, and the offense is no longer open, under investigation or pending, I'm not sure that they could refuse that under the law which puts that concern back on you and your client. Do y'all want to spend some time talking with the state? If the state wants to make an exception to their policy on this case, I have no problem with it. I just want to make sure that everyone's clear. And if that's it, if this is the agreement, I'm just gonna want the state to sign it. If it's not, and that's a pretty big concern, as I understand it would be for me as well, then I want to make sure y'all get on the same page. Y'all want to spend a few minutes talking about that for just a moment? Yes, and I'll tell you what, let me give you this back to, that way. I'm just gonna give you this one page. I'll keep the rest. Mr. Altman, if you don't mind, sir, just have a seat. I'm gonna recall you back up in just a moment.
Judge, Mr. Bingham signed off on the discovery.
Thank
I
you.
just didn't pull over for
Makes
whatever.
me feel better. We have any other counsel that's ready? Mr. Hawkins, you ready? All right, Mr. Hawkins, who are you ready on, sir?
Which I gotta do James Wright.
James Rife, CR 21-307-308. You can come this way, Mr. Rife. Mr. Rife, you come around that way. I know I'm trying to kind of change up procedures on you a little bit. Not trying to make it hard, just trying to make it difficult. All right, this is Mr. Rife, and we are set for docket call today. Go ahead, Mr. Hawkins.
Your Honor, we're asking for a formal passage. We've got some negotiations on the same. So we're working on that. And I think it's pretty quickly. We're going to be seeing a lot of fellow discovery. Everything's legal. Negotiating some of these.
Mr. Woodwide, Mr. Rife's asking for another setting for docket call. I'll show that we're up to 9 settings on this case, each one open.
Judge, the state did just extend a new offer to Mr. Hawkins yesterday. I don't believe he's had time. If we could set it for one final docket call, and then have that be decision day, whether we're gonna set this on the trial docket or accept the plea, that day, state would not be opposed to that.
All right, since the state's extending new offers, court will give Mr. Rife more time to consider that. Are you available on August 9th or 11th, Mr. Hawkins? Ninth or 11th.
I can do 11th, Your Honor. I've got a 3 days, same 3-day mixed trial, same jury trial. I don't think it's gonna be that long that I should be coming out.
Okay, all right, court will set Mr. Rife then for a final docket call on August 11th. That'll be at 9 a.m., Mr. Rife. Once you sign and get the yellow copy, you're free to go, sir.
Thank you.
Are you ready on Royce White?
I am, Your Honor.
Mr. White, CR 21-398, CR 22-51. Mr. White set for docket call today.
Your Honor, kind of thing announcement, we had received an offer from the DA's office. Told my client about the office this morning. So I will negotiate the thing to do one. So we're asking for a pass.
Same agreement, Your Honor.
All right, court will reset Mr. White for docket call on August 11th. 9 a.m.
Thank you.
Is Ms. Wortman back?
She is, Your Honor.
All right.
Matt Roach.
You may. Veronica Wortman, CR 2319. All right, Ms. Wortman, the state has tendered a motion to dismiss in your case in the interest of justice. Court will grant that motion and the case is dismissed. And Mr. Hawkins, give this back to Ms. Wortman for her records. Yes, thank you, Charles. Mr. Schmidt, you ready? Jacqueline Jacobs, CR 2255. All right, Ms. Jacobs is set for hearing a motion to revoke or motion to adjudicate.
That's correct, Judge. That was our first study. Just reviewed the motion. I believe we'll have a resolution. Set up for that. 26 docket. We can start with Docket. I think that would be good.
All right, court will set Ms. Jacobs then on the contested docket on July 26th. That will be at 9 a.m. Ms. Jacobs, once you sign and get the yellow copy, you're free to go. We'll go ahead and take up Cody Ledbetter, CR 22-186-187. He's set for arraignment today. The court has verified he's in custody in Kaufman County. Mr. Schmidt, if you don't have any updates for the court or information for the court on what he's being held there on, I'll just reset the arraignments.
Judge, I didn't know that he's leaving out of the County. 2 days they can't charge them. Here's one of his, additional charges, run Coffee County, money that's not. Felony that he's doing with this. It's got a bunch.
I see that Mr. Nicholas is on the bond at this time. Do you know if we are anticipating a surrender or Mr.
Judge, but I would anticipate it.
Okay. All right, court will, without more information, court will reset Mr. Ledbetter for arraignment in each one of these cases. And I believe that we set some for August 11th or August 23rd. When did we set your last ones? This week, earlier this week? Couldn't remember if it was 9th, 11th, or 23rd.
Believe me, nine.
9th. Okay. All right, court will reset for status and arraignment on August 9th. And that may become 1:30 if he's released from Kaufman County. I guess he was on bond though. May remain at 9. Guess if he's still on bond here. Yes, sir.
Yes, we agree with that. We just understand those will be the exceptions and we'll file a dysfunction with the above exceptions. That probation and liaison officer through retainer files.
Okay. All right, Mr. Altman, you'll come back up.
The only thing that's not blank on there was the number of team service hours. We were requesting, I don't know, it's typical here. I know Mr. Altman works, out county, long hours. He can tell wants to know exactly what he does, but he does work a lot. We requested 30 hours. So it's all.
The policy of the Community Supervision Corrections Department on a Class B misdemeanor is 100 hours. So what's the front end? It's 100 for everybody. I think for everybody, so. But he's got 2 years to do it. That's good news. Didn't have to do them all at one time.
Okay, well, we thought we'd ask.
Yeah, so 10 hours a month or 10 hours a month done in a year, 5 hours, you know.
It's just, I know, I bet the answer is no, but I know in, Harrison County, they'll allow you to pay for sickness.
You're allowed to pay.
Pay in lieu of.
No, but I think we do have a program where there's possible donations to some food pantries.
Okay.
Yeah, you can redeem 25% of your community service with monetary donation to an approved food pantry program within the county.
Maybe that's what I'm saying. Okay, thank you.
All right, Mr. Otmo, the court is going to find that you have entered into this contract potentially knowingly, voluntarily, with the advice of counsel, that you understand the terms and conditions of the contract, that you have waived your right to a jury trial in this case, that you've stipulated to the admissibility of evidence attached into this contract, and that you have waived your right to a speedy trial, and you've also waived your right to expunction of the records of the Van Zandt County Criminal District Attorney's Office and the Van Zandt County Community Supervision and Corrections Department. Court will approve your placement in this program. All right, Mr. Otmo, you can come over here and visit with the Community Supervision and Corrections Department, and they give you more information about your next steps, okay? And ma'am, you can come with him if you want to.
Judge, it's my understanding, I would say we filed this dismissal in the charged here, so we're not coming back. The Axon case they refiled in this year. So the Axon will be dismissed.
We'll be submitting a motion to dismiss shortly.
And the judge, that's all I have. Call it even. Just got to excuse.
Yes, thank you, Mr. Bingham.
Thank you, Judge.
Good to see you. Mr. Mims, are you ready? Shane Baronet, CR 2261. Mr. Baronet, you can come the other way. However you want to.
How do we have to waive the jury trial form?
Yes. Yes, sir, please. Smart. How you doing? All right, Mr. Baronet, if you'll do me a favor, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear or affirm that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, thank you. You put your hand down. Mr. Baronet, I have a document in your hand that your attorney, Mr. Mims, has handed me, indicating that you wish to waive your right to your jury trial in this case and enter a plea at a later date. Is that correct? You understand that you have the absolute right to have your case tried before a jury of your peers here in this court? You understand that that right can't be taken away from you. However, you can waive that right if you do so intentionally, knowingly, voluntarily, of your own free will. You understand that if the court approves this and allows you to waive your right to a jury trial, that right may not be given back to you at a later date. Meaning that if you waive your right to a jury trial today and you decide before you come back that you don't want to enter into a plea agreement, you still have the right to a trial, but it will not be before a jury. It'll be before the court. And you feel like you've had enough time to discuss your case with Mr. Mims in addition to this waiver that you're making today?
We have some more talking to do with the VA on a resolution. That's we need some time to work that out. That's the reason we're filing this today. So we just need a little extra time and answer your question on that. We will please.
Okay, well, Mr. Baronet, let me rephrase my question then. You feel like you've had enough time to understand what waiver you're making today You appreciate that waiver and you're asking the court to enter that based on you doing that of your own free will.
Yes.
All right, and Mr. Mims, do you believe Mr. Baronet to be competent to make this waiver?
He's confident.
You've explained to him the consequences of his waiver of a jury trial. All right, court finds that Mr. Baronet has been admonished regarding his right to a jury trial and the waiver thereof. Court also finds that he has been joined by counsel, and the state of Texas has also agreed to the waiver of the jury trial in their case. So the court will approve the waiver of jury trial, and we will set this for a plea. How much time does defense and state need?
Judge, I will defer, the state needs to meet with their, victim in this case. I believe that Ms. Cheney was gonna try to schedule something next week. I don't know if she's confirmed on that or not. State is comfortable with the 30-day reset, Your Honor, but this is going to be a time offer, so we would ask that it be set at 1:30 at the jail.
Mr. Mims?
That's fine, Judge. I'd heard August 11th earlier, so others, I checked my calendar, we'd be available that day.
All right, court will set Mr. Baronet to enter his plea before the court on August 11th. And that will be at 1:30, and that will be at the Evanston County Justice Center.
Excuse me, sit beside there.
Yes, once you sign, Mr. Baronet, and get the yellow copy, you're free to go. And I want to correct the record. I called Jason Lee Mays earlier. And I believe that Mr. Mays is actually set to appear at 1:30 to enter his plea to custody. So we can mark that off as a nice side. Mr. Adams, are you ready?
Yes, Your Honor.
All right, Mr. Baronet, I'm gonna have you step to the back so I can continue calling these other cases. Carlos Gatlin, CR 21288.
He's present with counsel, Your Honor. We have had an issue historically in this case regarding obtaining dash cam footage from the arresting agency. I don't know if the court would recall this, but we had a screenshot from what I believe to be dash cam footage that led me to believe that there may be a suppression issue to take up. I'm informed by state's counsel that that video is now available, and I'll be picking it up from the district attorney's office before I leave town today.
Okay. All right, court will reset Mr. Gatlin for an additional docket call, August 9th or 11th, Mr. Adams.
Either one's fine, Your Honor.
All right, court will
11 might be better.
11's better for you. All right, court will set Mr. Gatlin then for docket call on August 11th. That'll be at 9 a.m. Once you sign and get the yellow copy, Mr. Gatlin, you're free to go, sir. All right, court recalls CR 21-211 State versus Tavares Drell Dixon. So just for confirmation, the court did indicate to Mr. Dixon that he could appear via Zoom if he paid the $380 delinquency to pretrial release before the court date. And it's my understanding that Mr. Dixon has not complied with that condition to allow him to not be present in court today. Is that correct?
Correct, Your Honor. I would add that my legal assistant has been in touch with Mr. Dixon this morning, which is why I'm able to report the updates that I have. She advised him to make that payment as quickly as possible. She provided the number for the county number to call to make that payment. I asked about 10 minutes ago, she'd heard back from Mr. Dixon as to whether or not he paid yet. Her reply was that she hasn't heard from him yet.
Okay. All right, court will have his name called at the conclusion of the docket again. And if he fails to appear, or if he fails to contact you, Mr. Adams, or your office with confirmation of the payment, then the court will enter a judgment not signed, forfeit his bail bond.
Yes, sir. Your Honor, does the court care who pays that?
Well, the issue was supposed to have been resolved before the court so that we wouldn't be having this conversation. So to answer your question, no, I don't care who pays it, whether the defendant pays it, his grandma pays it, or anyone else pays it. However, I wanted this done beforehand so that I could in good faith allow him to appear via Zoom and not wait till the last minute.
I'd rather have done it that way myself. If it's taken care of before noon today, would that have?
I would-
on the nice side?
As a professional courtesy to you, Mr. Adams, yes, I would allow that for you.
I appreciate that. May I approach, Judge?
You may,
Judge, may I approach?
you may.
I'll raise up here. Me first.
This,
You're dismissing all of Mr. Adams's cases?
all of them, all at the same time.
Wow. That's Mitch Adams, attorney in Tyler, Texas.
Yes, sir. I'm John Adams. Got the touch, it's all on the wrist. It's all on the wrist. Thank you, Judge, just so we can get him a copy before he says. I've asked Casey Ashmore to announce for me this afternoon. I've got.
I'll call Mr. Brand's name again at the conclusion of the docket. And then I will issue a judgment not aside, but I will take it under advisement for 3 days. If his family or Mr. Manning opportunity to produce some
That's
documentation and support stuff.
absolutely, Judge. That sounds perfectly reasonable. I just wanted to make sure we had our record straight.
Mr. Bogan, are you ready, sir? Or do you need time? I'm not. You need time, that's fine.
I'm ready to say, Martin, Michael Villalobos is, I believe, about 15 minutes away from the courthouse. I've been in contact with him, so that we can go down.
Yeah, Ms. Martin, if you'll come up. CR 1424. Sir. We're playing musical podiums. So. All right, Ms. Martin, if you'll do me a favor, man, when you raise your right hand, so I can place you on oath. Ma'am, do you swear or affirm that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God. Your name is Terry Anise Martin, is that correct?
Yes,
Ms. Martin, you appeared before this court previously on the charge of possession of a controlled substance, penalty group 1, less than 1 gram, a state bill felony. That was back on May 27th, 2014. The court on that day heard the evidence in your case, found that there was enough evidence to convict you of the offense. Court found that you wanted to enter into a plea agreement to resolve your case, and the state recommended that your case be placed on deferred adjudication, and the court approved that and placed you on community supervision for 4 years. And on December 8th, 2000 and Can we approach?
Yes.
Moved up today. Let's see.
It's time served under 1244A, Judge. She successfully completed the Bowie unit.
We're going to spend recess for about 20 minutes. That would be strong. All right, this is cause number CR 2215, CR 2264, State versus Michael Elias De La Rosa, set for pretrial. Go ahead, Mr. Bowman.
Yes, Your Honor, I request one more pretrial setting. The state, I had not realized until this week that I did not have discovery on one of the two cases. I requested discovery and received it yesterday from the state. I've communicated with Mr. Woodwhite. And we're in agreement that another pretrial setting on this case would make sense.
The state's agreement, Judge, we had not realized, I believe that there was another attorney for some reason on this, even though we have no record of why there would be another attorney, so I think somebody just typed the wrong name and said it to the wrong attorney, and they never told us, we were unaware that Mr. Bogan didn't have discovery, so we have rectified that, we would not be opposed to it.
Okay. All right, court will reset Mr. De La Rosa for an additional pretrial to allow Mr. Bogan to access and review discovery. Do you have your calendar, Mr. Bogan?
Yes.
Look at August 9th, 11th, or 23rd.
Since I'm set for trial the week of the 8th, I think the 23rd would be best.
All right, court sets Mr. De La Rosa for pretrial in each case, August 23rd. That'll be at 9 a.m. Mr. De La Rosa, once you sign and get the yellow copy, free to go.
Good to go. Yes. You already signed it.
Yes.
Thank you.
Thank you, Mr. Bogan. I will bring Mr. Taylor in.
I unmute.
All right. Good morning, Mr. Taylor. Can you see and hear me okay?
Yes, sir.
All right. Mr. Taylor, my name is Judge Chris Martin. This is the 294th District Court. And Mr. Taylor, this is cause number CR 22195. You have been charged, sir, with the criminal offense of unlawful possession of a firearm by a felon, a third-degree felony. It's my understanding that you have contracted COVID. So the court's allowing you to appear via Zoom today. Today's setting is for arraignment, and arraignment is where we affix your identity and make sure you understand what you're charged with. My first question for you, though, Mr. Taylor, is are you requesting a court-appointed attorney, or are you going to hire an attorney?
Co-vote.
Court-appointed?
Yes.
Okay. And when you were in jail, did you submit any paperwork at that time requesting court-appointed? No? Okay, so what we're going to need to do is get some paperwork to you, and you're going to need to fill it out so I can review your finances to see if you meet the requirements under the law. Okay. So do you have a good email address that I can send it to you, or do you want to come up in a few days to the Indigent Defense Coordinator's office?
If it's for the indigent lawyer, I'm his daughter, Nicole Taylor.
Okay.
I spoke with Patty and I filled it out, and because he lives in his house, he doesn't qualify for indigent.
All right. Thank you, Ms. Taylor. That does remind me. Yes. So, yes, because you do own a home and you have some financial income and your expenses do not rise to the level to allow you to meet under the legal requirements. Thank you. That does refresh my memory. So, Mr. Taylor, what I can do is I can reset your case for 30 or 40 days, give you an opportunity to see if you can save up some money or get a loan and go hire an attorney to represent you.
Y'all don't do court-appointed lawyers with it being a felon charge?
Well, so we do court-appointed lawyers, but in order to get a court-appointed lawyer, you have to be under the legal guideline financially. And due to Mr. Taylor owning a home and having other income, it makes him higher than the minimum. If he was below this minimum level as set by law, then he would be deemed indigent and he would receive court-appointed attorney. But he's above that because he has assets and he has income that exceeds his expenses. So the law, in the eyes of the law, he makes enough money to hire an attorney. It is not.
But he only gets $1,200 a month with his social security.
I understand, but it also says that he owns a home. And he's
Yeah,
got,
he owns an RV and he lives in that.
right, so he has an asset or something. It'd be the same as if he just owned vehicles, if he just rented, but he owned vehicles that were worth $10,000 or $15,000 and he had income and his expenses didn't exceed the value of his assets and his income. So
Okay.
in the eyes of the law says that you can go and ask for a loan against that RV or any other assets that you have, or you're able to save up money or ask for a loan for friends or family. Okay, so what I can do is let's reset you until like August 23rd. That'll get you through your COVID issues, and that will give you about 40 days, 45 days for you to try to get some funds together and figure out a possibility of hiring an attorney. Some attorneys take payment plans. There's some things that you can do between now and then to try to get representation. Okay.
Okay. Thank you.
Okay. All right. So Mr. Taylor, I'm going to give you this notice in open court. Since you're not here, I can't give you a letter with a notice of the day. So I'm just giving it to you in open court, August 23rd at 9 a.m. That's your next setting, August 23rd at 9 a.m. And that will be here in the courthouse, and you'll appear in the courthouse on the top floor. Okay, sir?
Thank you.
You're very welcome. We'll see you back on August 23rd with your attorney. Okay. All right. Thank you, sir. Have a good day.
Okay.
All right, Deputy Phillips, if you will do me a favor and call the following names loudly, distinctly, 3 times in the courthouse. Tavares Dixon.
Yes, sir.
Bobby Brainerd. Those are the only ones. Not yet. So I'm gonna have his name called, and then I'm gonna do a judgment nisi. I'm gonna take it under advisement till the end of the week. Well, today's Thursday. Probably give them till Monday or Tuesday of next week. And then if there's documentation to support that, then the court will withdraw that nisi. Thank you, Deputy Phillips. Sorry, the court has had the names Tavares Dixon and Bobby Brand called this morning at 9 a.m. They were not present in the courtroom. They are not present at this time. At the conclusion of the court's docket, their name has been called loudly, distinctly 3 times in the courthouse with no response. Court hereby issues a judgment nisi for Tavares Drill Dixon. The court has indicated to Mr. Mitch Adams that the court will withdraw that judgment nisi should Mr. Dixon pay the amount of money that he owes to pretrial release prior to noon today. The court would allow Mr. Dixon to appear via Zoom. That was for plea. Obviously, the court would have to reset that plea. With regards to Bobby Brand, the court will issue a judgment nisi in alias capias, but the court will take that under advisement until Wednesday of next week at noon. so that Mr. Manning or the defendant's family or Easy Pickens bail bonds can provide documentation that Mr. Brand is in the Palestine Regional Psychiatric Unit and unable to be in court today. So that's under advisement until Wednesday, July 13th at noon. All right, and I believe I said this for the record, but Jason Lee Mays will be called at 1:30. There's no night out in that case. Court will then stand in recess until